Is the California magazine ban now in full effect? CRPA's Duncan versus Becerra lawsuit unfortunately failed. But are you now a felon? Well, let's get into it. Duncan versus Becerra is the lawsuit, and there is now a final judgment that's been published. So what exactly happened? Well, this lawsuit, if you're not familiar, Duncan versus Becerra was a lawsuit against the ban on possessing magazines. It was really already in existence. There was a ban on buying and selling, importing, taking possession of a magazine that held more than 10 rounds. And then the state of California put into law a ban on even possessing these magazines. So there was a lawsuit filed, and everybody remembers this is how we discovered Judge Benitez, Saint Benitez, because he came out with an extremely strong ruling that said, no way, a magazine ban like this is completely unconstitutional. And then we had Freedom Week. Now, if you owned a magazine, whether you purchased it that week or you already owned it, if you had a magazine during Freedom Week that held more than 30 rounds, Judge Benitez exempted you. Said, okay, you're still okay. You can own these. Again, whether you purchased it, whether you already owned it, whatever. If you had this magazine during Freedom Week, he said, okay, I'm going to put a stay on my order, meaning that his order wasn't in effect yet. Okay. But if you already own these magazines, if you possess them, then you're good to go. So if you had magazines that held more than 10 rounds because of that order, they were totally legal. Well, what happened was that just this last week, the Ninth Circuit Court of Appeals had an en banc panel, which means that they had 11 judges look at this and evaluate it. And it had been there for a while. They were really, really stalling on this, which we thought was good news. But now they've come out with the final ruling, and the final ruling says that the ban on possessing, on buying, on selling, on importing magazines that hold more than 10 rounds comports, that was the actual word that they used with the Second Amendment and the Bruen decision, which is just absolutely ridiculous. And we're going to talk about why. One of the judges that ruled against your rights, Judge Susan Graber, said, quote, a large capacity magazine has little function in armed self-defense, but its use by mass shooters has exacerbated the harm of those horrific events. Murderers who use large capacity magazines need not pause between shots until they have fired 20, 30, or even 100 rounds. These pauses are crucial. Victims and law enforcement personnel take advantage of short pauses in firing to flee, take cover, and fight back. A mass shooter's use of large capacity magazines limits those precious opportunities. I don't understand how she doesn't see the other side of that. That also works when you're defending yourself. And in fact, people defend themselves with firearms far more than, crime is committed using firearms. But that was part of her reasoning.
I'd also just like to point out that that is just not true. Murderers who use large capacity magazines need not pause between shots until they have fired 20, 30, or even 100 rounds, is her direct quote. Find me a single mass shooting incident where a mass shooter fired 20, 30, or 100 rounds without pausing. It does not happen. That is not a thing. Mass shooters consistently have malfunctions. They have bad guns. They don't know how to use their guns. They stole their guns from their dad or their grandpa or whatever. Very, very frequently, they have absolutely no idea how to shoot their gun. They have malfunctions at a very high rate. We see it in CCTV footage. We see it in body cam footage from police response. There are consistently issues feeding rounds into their firearms, no matter what kind of gun they're using, what kind of magazines they're using. I do not think that there is a single mass shooting incident that has ever happened where there were 100 rounds fired without a pause.
Yeah, I can't even think of one where I can't think of a single, mass murder where a gun was involved where the person was stopped because they were changing a magazine. The other thing is, if we're relying on a criminal's inability to quickly change their magazine, for public safety.
We've got a bigger problem.
It's just
That's a giant
ridiculous.
issue. Yeah, I mean, I do think there are some cases. We've seen some cases where like children recognize. I think there was a maybe even at Sandy Hook. I might be misspeaking, but there was a kid who recognized, oh, this is a magazine change because he had been shooting with his family before, and he got some of his buddies, and they all left the classroom, and they were the only kids that didn't get killed in that classroom. So I do think there's benefits here to obviously. People needing to reload their gun while they're committing crimes. That's good that they have to reload their gun. But what does this have to do with legal firearms owners using firearms for self-defense or for recreation or for any other reason we want to use our firearms? The concept here that banning high-capacity magazines will stop mass shooters or will lessen the deaths that occur from mass shootings is just preposterous. They don't even generally own their firearms legally. Why can't we just... There's already laws on the books for all of these things. Murder is already illegal. Why are you just going to add another level of difficulty for law-abiding gun owners?
Well, we have to understand that the judges who ruled on this and wrote the decision, and by the way, only 3 of the 11 judges dissented, and we'll talk about that in just a minute. This isn't logical. They weren't making a logical argument. That wasn't their intent or their purpose. What they did is they actually twisted and turned the Bruen decision and kind of shoved it back in the Supreme Court's face.
Yeah.
I mean, it really, truly, it's not hyperbole to say that they kind of, gave the middle finger to the Supreme Court and said, hey, we're going to use your text, history, and tradition test against you and, shove it right in your face. Basically, we're going to rule against what you were intending and what the Second Amendment intended and what the framers intended, and we're going to shove it right in your face. Now, what do I mean by that? Well, one of the things in the decision against us was they said that the text of the Second Amendment doesn't say that it's legal for people to own magazines that hold more than 10 rounds. They were saying, hey, if you say we got to go by text, well, there's no text in the Second Amendment that says anything about magazines that hold more than 10 rounds. That is the most obnoxious, ridiculous, legal-minded excuse for a decision I think I've ever seen. I mean, it really, truly is. This isn't her understanding or their understanding, the multiple judges. This isn't their understanding of the Bruen decision. This isn't their understanding of the Second Amendment. This isn't a sincere effort to comply with the Bruen decision or follow the Second Amendment. This is absolutely a middle finger to the Supreme Court. It says the U.S. has a tradition of gun regulation, so they're actually putting language in there, again, to use text, history, and tradition against us, to twist it and turn it around. Nobody out there, there's not a single person out there that says, hey, you know what, that Bruen decision, that is definitely, I'm glad that's in place because now it's easier for us to ban firearms and firearms parts. Nobody thinks that. They absolutely had to make this up. It's totally delusional, and they aren't judges, they're activists. The dissent, in this case, we're the dissent. The good guys are the dissent. They're the ones that, because the majority of the ones that wanted to take your rights away, the dissent are the ones that wanted to make sure that your rights were preserved. And I wanted to read just a little bit from a part of the dissent. Magazines are arms. Magazines, whether they hold 10 rounds, more than 10 rounds, or fewer than 10 rounds, are unquestionably arms under the Second Amendment. As a textual matter, arms include any weapons of offense or armor of defense or anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. That is carried for the purpose of offensive or defensive action. And that, of course, they're talking about, they're actually referencing Heller in the dissent. Arms then extend prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. At a minimum, the meaning of arms, quote, covers modern instruments that facilitate armed self-defense, which is directly from the Bruen decision. So there was a lot of discussion, and then you can talk about, by the way, what a magazine is. A magazine is a container possibly detachable, and a repeating rifle or machine gun, etc., containing a supply of cartridges, which are fed automatically. They kind of talk about the actual definition of it. But there was a lot of discussion over whether or not a magazine is a necessary part in a firearm or an accessory. And it was basically made clear that is the only type of magazine that can't be banned would be a single shot magazine. That anything over single shot, if it held 2 or more rounds, then it was simply an accessory. It wasn't a necessary part of the firearm, which is absolutely ludicrous. Absolutely ludicrous. Now, Van Dyke, right? Is the name of the judge? Judge Van Dyke. He put up about an 18-minute video that was a dissent, and basically explaining how firearms worked, because he knows what he's talking about. Did you watch the video?
Not the whole 18 minutes, but I saw pieces of it.
He legitimately seems to be a firearms guy who understands what firearms are all about and the way they function. And he did a really good job. But the reality is, we frequently make this mistake where we're looking at this ludicrous decision and we're trying to apply logic to it.
I know.
And it's not logical. Like you said, this wasn't an honest effort to get this right. This was, mental and legal gymnastics. And again, using the Supreme Court's decision against them. They clearly don't agree. And this was kind of a snotty response, really.
Yeah, what's interesting about this, too, is that there's still exemptions for law enforcement, active and retired, and there's also exemptions for security guards of armored vehicles. Well, if those people need high capacity or standard capacity magazines in order to do their jobs well, and armed citizens with concealed carry permits are often needing their guns for similar things, wouldn't it be the logical thing to assume that all of those parties could use and benefit from standard capacity magazines?
Well, in the Constitution, especially the Bill of Rights, that is a limit on government. So anytime a judge, an activist judge, like in this case, gives the government more rights, than the citizens, they're completely way off base. There is no justification to be made that, hey, you know what? The government has a little bit more freedom with their speech than citizens do. Or,
right.
Hey, you know what? The government, they're allowed to, practice religion or assemble or whatever. Yeah. Any time that they say, hey, your government has more rights than you are, which is exactly what law enforcement are, that is your government. You're completely and totally wrong. So let's talk about what happens. Supreme Court, maybe, I got to tell you, highly unlikely. I mean, in our 249-year history, we've had 4 Second Amendment cases that have gone to the Supreme Court. Even if it makes it, it's still highly unlikely. I mean, it's just highly unlikely that this case is going to actually make it. I mean, lightning could strike too, right? Just to give you some context, in the history of the U.S., the Supreme Court has seen around 26,000 cases. They see about 60 to 80 cases per year in modern times. Meanwhile, thousands of people want them to see their case. Could it go? It could go. It could absolutely go. Will it go? I got to tell you, it's just unlikely. I mean, just the numbers and the history just don't quite support it. But who knows? Who knows what'll happen? Maybe the Supreme. I got to tell you, in politics these days, nothing would surprise me. I don't think this is something we can count on, though. I don't think we can absolutely count on the Duncan case going to the Supreme Court. Even if it does, it's not happening today or tomorrow. It's not, happening anytime soon. Again, if it does, what a miracle, But trying to rely on miracles, that's just not the way to go. So what does this mean? Even if the Supreme Court eventually does rule on this, what does this mean for your magazines? Well, the reality is, so right now you don't have to do anything. Don't do anything. If you have magazines that hold more than 10 rounds, just sit tight. What's going to have to happen is that this decision gets kicked back down to the district. The district, then puts out an order. That takes a little bit of time. And then from there, it'll be clear on exactly what'll have to happen when it comes to magazines that hold more than 10 rounds.
Yeah.
Could they still grandfather in the Freedom Week? I think that's highly unlikely at this point. At some point, I think the most likely scenario, if I'm looking in my crystal ball, is that magazines that hold more than 10 rounds are going to be illegal to buy. They're going to be illegal to sell. They're going to be illegal to gift. You can't give it to somebody else. And they're going to be illegal to possess no matter when you possess them, no matter what date. You're just going to be a grandfather clause. Yeah. At some point, you're going to have to make a decision on what you're going to do with your normal capacity magazines that hold more than 10 rounds.
Well, you actually don't have to decide, because they decided for you. They gave you 4 choices. You can remove it from the state. You can sell it to a licensed dealer. You can turn it in to law enforcement for destruction. Or you can permanently alter it so that it can accept no more than 10 rounds.
Yeah, but we don't know. Not today. Just
right.
Hold on. Yeah. Hold off. Not today. Wait until the actual order comes down. But yes, they absolutely. Those I believe at some point will eventually be your options. But don't do anything yet. Just sit tight. I'm not an attorney. This is not legal advice. So just sit tight and wait for the actual order to come out. But again, this is. We have to understand lawsuits are important, but we can't rely on them, and it's not the only arrow in our quiver. We have to get the right people elected. At this point, I think it's equally as likely that we get this law reversed by Sacramento as it is that the Supreme Court steps in and reverses it, through a lawsuit. So. It's important to get the right people elected. It's important to focus on activism, making sure that you're helping people get elected, that you're helping people get more involved, and we're here to help you do that. So, unfortunately, and there, by the way, one of the factors that does weigh into whether or not the Supreme Court will take it is, and it's kind of an interesting point, is, this en banc, I don't know if you remember, but during the process and procedure, at some point, the Ninth Circuit said, you know what, we're just going to take this case to an en banc, to an 11-judge panel. We'll take it. Skip the process. We're just going to take it and we'll decide. There's a lot of discussion on whether or not they even had jurisdiction, whether they were even legally allowed to do that. There's very distinct possibility that the Ninth Circuit screwed up and that this could be, at the very least, delayed and done over, but at most this could be completely wiped off the books. I think more likely scenario is that it would be, it'd be a do-over, but still that's another reason that this could get reviewed by the Supreme Court. But we cannot just rely on that. We have to get back to good old-fashioned activism, getting the right people elected, raising money, spending time, getting people involved, and doing the things that effective activism can get you. So stay tuned. When the order comes, you'll know. Keep in touch with Gun Owners Radio. Make sure that you're following us and subscribe, and we'll make sure to let you know when things happen. I wish this had gone better, and I wish I had better news for you. Hey, everybody. Thanks for watching. I'm Michael from Gun Owners Radio. If you liked what you saw, please don't forget to like, subscribe, share, and make a comment. Help us out. Go to gunownersradio.com. Thanks for watching.